Welcome everyone to our Lunch and Learn webinar today. We are going to go over some new updates and important reminders for 2025 in today's webinar. I'm Stephanie and I work in compliance and I'm a special projects manager at Reference Services. Just a reminder, we are recording the webinar today and the recording and slides will be sent via email within the next day or two. As always, we would like to start with our legal disclaimer. As you all know, we are a consumer reporting agency. We are not attorneys. So any information given in today's webinar is educational in nature and should not be considered legal advice. Presenting today along with me will be Brad, RSI's President and COO, Alicia, our Director of Compliance and Operations, and Heather from our Client Services team. We have a lot on our agenda today. It includes a look at compliance and criminal records reporting, reviewing some recent fee increases, RSI's data retention policy, sharing of consumer report information with third parties, hiring policy reminders, continuous monitoring, challenges with individual states, and rounding it out with a look at our current integrations. Throughout the presentation, if you have any questions at all, please submit them in the Q&A and we will gladly address those questions.
All right, well, thank you, Stephanie. And again, welcome everybody. Thanks for joining us today. We'll try to get through all this pretty quick. We're going to start off with an announcement that we made on Monday. And basically that announcement is the adoption of a 7-year reporting standard for criminal convictions on your consumer reports. This aligns with a growing trend towards fair hiring practices and compliance with the Fair Credit Reporting Act. And I will say this is a topic that has been around the Professional Background Screeners Association for some time. In our fall conference, it was a hot topic and lots of discussions on the legal side and various reasons for kind of moving in this direction. I'll try to cover some of those today. Again, any questions that you may have, just put those in the chat and we'll try to answer those along the way. But I wanted to start off with just reminding you that the current federal rule is that convictions are reportable forever. Non-convictions, pendings, and deferrals are reportable for 7 years from the charge date or the file date. And then on top of that, you obviously have many state restrictions, and this probably started the conversation the most a few years ago. You have now 9 states that already impose some kind of 7-year restriction. California, Montana, Massachusetts, and New Mexico have strict 7-year reports. That means regardless of income, they don't want anything reported beyond 7 years. Then you have another handful of states, Kansas, Maryland, New Hampshire, and Washington, all have a 7-year rule, but they have an income threshold that applies to applicants that make $20,000 or less. So you already have this state flow of kind of limiting things at a 7-year scope. Secondly, some of the records that we see beyond 7 years are simply just not complete or not reliable. We have many cases on a weekly basis where we're chasing things that are old records that are very difficult to deal with. One of the most recent ones is one where there was a charge, say, I think it was 42 years ago. There was a dismissed charge, and just quite frankly, the record on the court records just never got updated. And we see that all the time. Things in the last 7 to say 10 years are fairly reliable because of technology. But if you start getting back into 15, 20, 30, 40 years, a lot of that was a manual process, paper chasing, and that has a lot to do with the reliability of records beyond, say, the 7-year period. Also, your county criminal search is based on a 7-year address history. When we send the invitations out to your applicants, they are being asked to give us their personal identification information. They're asked to give us 7-year address history, and that kind of starts the foundation for, quite frankly, that most of them think that limit is 7 years. They read it online. There's many states that have their own state regulations, and it may not apply to the state that they're in. But we get calls all the time from applicants who already think that it's 7 years. And quite honestly, when we put out this announcement on Monday, we had some emails from clients and saying, what's new? We thought it was 7 years anyway. So there's lots of confusion out there as to what is reportable and what is not. And then lastly, I think the EEOC encourages employers to consider the nature of the offense along with the time since the conviction when making a hiring decision. So trying to be in line with not only the Fair Credit Reporting Act, but those EEOC requirements, the 7-year standard scope makes a lot of sense. Um, Lastly, we have a lot of clients that are already, as I mentioned earlier, using the 7-year scope process. Now, I will say, and we've tried to communicate this clearly, but RSI will continue to report major felony convictions under the maximum federal rule, which is felonies for life. And so when we think of major felony convictions, we're talking child abuse, sex crimes against minors, child pornography, sexual assault, homicides, kidnapping, robbery, terrorism, harassment, things of that nature. You'll continue without any type of special instructions, continue to see those records reported. Now, we do recognize that there are some very restrictive industries out there when it comes to wanting to see the maximum. And we recognize that healthcare and anyone dealing in child services, whether that is a school or anyone dealing with children, they have policies where they want to see everything, and we recognize that. So those clients in healthcare and child services will continue as they are today, seeing the maximum reporting under federal and state law. We also recognize, and I think it's one of the values of reference services, is that we try to customize everything to client need, and we'll always do that. So if there's some confusion, or if you want to make sure that we're reporting to your specific needs, and you need something beyond this standard 7-year scope, just send us an email at help@referenceservices.com and just say, hey, I want to keep my scope the way it is. Today, we're doing some things, misdemeanors as an example, up to 10 years, or you want to see everything to the federal and state requirements. We'll put special instructions on the client file so that our team, when doing order review of criminal reports, will report exactly as you need those. Just a reminder, this begins on January 1st, giving some time for our clients to kind of vet this out and have communication with us to make sure we're all on the same page before we make any changes. And then next, we've got some information on Work Number. I'll let Alicia jump in, I think.
Hello. So I am giving the update on the Work Number, which is used for employment verifications. So Equifax owns the Work Number, and they continue their process of annual increases for accessing their data. And this is a pass-through fee. Beginning January 1st, the rate will increase from $87.20 to $95.92. This is an RSI negotiated rate. The normal rate is $119, and this is something that every CRA struggles with because they own all of this data. Most that we've talked to are actually paying closer to the normal rate. So I guess we feel a little lucky that we're less than 100 still. And the reasons for the increases that the Work Number gives is they house 10% more data since 2023, 3.5 or 3.4 million employers contribute to their data, which is over 695 million records. So, and then because of the high prices, we're always exploring alternatives. So one of the things that we can do is add required documents for the applicant to automatically submit to us when they are filling out their background check through the Quick App process. They can also submit their own information to the Work Number. That's actually free for an individual to order their work history. It's just not for companies. And then they can provide that to us. Or we do ask them for tax documents now, but sometimes it's hard for them to find those. So we are exploring the use of Form 4506-C, which is a form the applicant would sign to authorize us to request tax return info from the IRS directly. So we're actually looking to test this or, start a client out on this. So if you're interested in this, let us know.
Yeah, thanks, Alicia. I think too, I'd like to just comment, there's a balance between your expected turnaround time and how long it takes us to capture this documentation from the applicant in order to report it back to you. So as Alicia said, we would like to test some of this stuff with a number of our clients. So if you're interested, just let us know. But we'll continue to see work number increases. There's no doubt. This is a trend they've been on now for 4 years. So this industry is definitely looking for alternatives.
Hello, everyone. It's Heather. I'm going to talk briefly about the drug testing increases that are coming in 2025. So actually, I believe they're in effect 12/1. So here in just a couple weeks. Most of these increases are due to things like increased cost of goods, clinic cost, that kind of thing, increased payroll on the collection site side. So when eScreen increases our cost, on occasion, we have to pass through a small increase to our clients. As many of you may know, there have been several years where we've absorbed that increase and have not increased the cost, but occasionally we must do it. It's not very significant. In most cases, we're seeing the drug testing $2 to $3 more. Some of the occupational health might be $4 or $5. But there are some alternatives. So if you ever want to explore, point of collection testing, and we also have an electronic employer collect for oral fluids. So there are some other options. If any of you want to explore those, certainly reach out to the help desk or your dedicated account manager. But just wanted to make sure everybody's in the know that there will be a slight cost coming up.
Thanks, Heather. I'll also add that we're exploring other alternatives outside of eScreen. There's other networks that are out there. The challenge is the size of the network and whether there's enough clinic locations throughout the country, and then also vetting out pricing compared to eScreen. That's a process that we're undertaking at the moment. So we hope to be able to announce, if not some additional alternatives, at the first of the year.
All right, and now we're going to take a look at data retention and a couple of topics about viewing reports. So RSI's policy is to maintain data, including copies of all reports, for 3 years from the order date. The primary reason for this is due to increasing class action litigation on the advice of our legal counsel specializing in FCRA compliance. If you have a need to retain reports longer than this time frame, we highly recommend that your company save a copy of any report that you need to retain past 3 years. And taking a look at viewing reports, when you're looking at your reports as part of the hiring process, please be sure to read the entire report. It's important that you don't rely solely on the summary that's located on the first page when you're making a hiring decision. The summary is just a brief snapshot letting you know there's further information to review within the report and doesn't define the level of the alert. You would need to look at the specific details of the report in question to determine if the information would be related to the position at hand before you initiate any pre-adverse or adverse action. Another reminder is that Social Security trace information cannot be used as the basis for adverse action on an applicant. It should only be used to verify or correct applicant info or as a tool to further research of public records. For example, this helps us guide the jurisdictions in which the local searches are conducted. Your written hiring policy should identify what types of records would disqualify an applicant based on the position. Next, we're going to take a look at sharing reports with a third party. In general, sharing reports with a third party is not recommended. As a reminder, RSI reports are only viewable by you, the end user of the report. The authorization provided by the applicant only approves for RSI and the end user, which is our direct client, to review the report. Anyone else given access to a report could be considered a violation under the FCRA unless certain conditions are met. For PEOs or hiring agencies, if you are a PEO, please be very careful with how background screening information is shared with your clients. If you are sharing reports, the courts may consider you a consumer reporting agency like Reference Services, which would require you to follow FCRA requirements for things like dispute reconciliation. The best process is to certify that the applicant or employee passes the HR policy of your third party. If it is necessary for a third party to view the actual reports, a separate end user agreement will need to be signed by the third party with RSI, and the third party would need to be added to the authorization form signed by the applicants.
All right. So just to mention continuous monitoring, that we have this available. If you rescreen annually or have high-risk positions where you have to audit annually or on a regular basis, consider the benefits of continuous monitoring. In most cases, the annual cost is less than a rescreen and provides daily or monthly monitoring to alert changes in records. So we have criminal court monitoring available, which includes traffic violations and federal charges, and healthcare sanctions monitoring, and medical license monitoring also for our healthcare clients. The rescreening options are available at various intervals according to client needs, monthly, quarterly, annually, depending on the RSI platform that's being used. And then just to go over state challenges, occasionally states will have cyber attacks or other technology issues, but the ongoing challenges for us are due to the Clean Slate Law. The law was introduced to the House in 2023, so right now it is a state-by-state initiative because it hasn't gone any further in the House. However, more and more states are adopting it. So right now, there are 12 states, including the ones listed, but soon Minnesota will make it 13. The issues that we face are public indexes are taken down, sometimes for months at a time, which means that searches are at the mercy of the clerk, which increases turnaround time, of course. RSI monitors orders daily to identify potential problem jurisdictions and to come up with workarounds wherever possible. So sometimes we might be able to run a statewide in place of a county or come up with a different method of getting those records. We update our platforms regularly to make sure that clients are aware of potential issues, and we also try to update orders as much as possible with ETAs.
Thanks, Alicia. I think this goes back to the 7-year standard reporting challenges that we face. I mean, these states are removing automatically with data, they're removing information after a 7-year window or after a particular period of time. They're all not necessarily 7 years, but that's what's happening. I mean, this clean slate is they're taking out criminal records that they just don't want us to see. And so that creates those further challenges. Lastly, just talk about integrations real quick. We spend a large amount of time trying to make sure that Reference Services is integrated with the top HR platforms and applicant tracking systems. This is a snapshot of those that we use the most. There's probably well over 4,000 different applicant tracking systems out there, but these are the largest ones and the ones that we have close connections with. We spent a lot of time this past year with Paylocity. We have a close, great working relationship with those folks. But I would just simply say, if you're not already integrated and you have an interest, just reach out to us at our help desk. If you're looking at one of these platforms and have questions about their integration, we certainly can give you some input as to how either one, are they expensive, or how to explore the differences in what these integrations will do, because they are all somewhat different on what they'll deliver. But we'll be happy to kind of guide you through that to the knowledge that we have. And then lastly, we announced this summer some new technology for when we do not have a direct integration, and that is using a Google Chrome extension. So if you're not familiar with the Google Chrome extensions, There is a Google store. You can download these extensions. There are tools that sit on your Google browser that allow you to do task while you're actually on your browser. So in this case, what happens is while you're on a candidate profile page, you can launch our Google Chrome extension, and you can start processing an order and send it to reference services for completion without having to log into our platform, which is exactly what an integration workflow does for you. So you can see here that we're on a Taleo profile page. This is an example, but again, it could be any HR platform, any ATS, it doesn't matter. This is strictly scraping over the applicant email and phone number, and then you hit start processing. And then simply at that point, you just have to add in the first name, last name, and select the package that we pre-configure on our side so it's available in this tool. Once you select the package, and there's no limit to the number of packages, you hit submit, and that sends a quick app invitation to your applicant from the RSI platform. And at that point, you're in a secure platform where we actually capture the personal data and get the authorization forms just like we do in any integration. Once that order is in process, you actually can see in the tool the status at the top. In this case, it shows a completed status. You see the package that was ordered, who requested it, the date it was requested, and then you have an order ID number too, which ties back into the RSI platform so that if you log in there, you can search by ID or your applicant name. Once the report is completed, you get notified through the tool, the Google extension. You can see here, you click view report, pops up a PDF, and then you have the ability to save that PDF into your files, save it into your applicant tracking system. We'll actually keep links inside the Google Chrome extension so you can look at historical files. So it's a handy tool. It's easy to implement, and we've had great success with our clients since the summer putting folks there. So if you have interest, just reach out to us there as well, and we'll give you more information. So Steph, I'll give it back to you for closing remarks.
Thank you. Yeah, we're just going to go over a few key takeaways and reminders as we wrap up for today. And Heather's going to be checking to see if any questions came in. I'm not sure. I didn't see any myself, but we will check in at the end. Oh, go ahead.
Nope, I have not seen any come in yet.
Okay. Thanks, Heather.
Thank you.
So these reminders, the RSI standard scope starting on January 1st will be 7 years. The work number fee is increasing for employment verifications. There is an e-screen price increase for drug testing and occupational health services starting on December 1st. There are alternatives for both of those. For the work number, the alternative would be using applicant documents. And for e-screen, there are alternatives with point of collection testing. Going on down the list, RSI, as a reminder, RSI data retention is for 3 years. Use care if sharing reports with third parties. Make sure you're following those best practices. Consider taking a look at continuous monitoring and rescreening if needed. Some states are reducing their PII, and just remember to keep in mind there are lots of integration options with RSI, including our RSI Chrome extension. As a reminder, check the RSI news and announcements section on the client portal often for important updates. You can also find updates on our website, on our blog. The last bullet point here, I think, is going to be the most important. If you have questions about any of these things, especially with the new standard criminal reporting scope or any fee increases, please don't hesitate to email us at help@referenceservices.com, and we're glad to answer those questions. Just as another reminder, a copy of the slides and recording will be emailed out to all attendees within a few days. And we'd like to thank you for attending the webinar today.